This court is back in session. The next argument is in the matter of Commonwealth of Pennsylvania versus Michael A. Lehman and Scott Charles Davis. Representing the Commonwealth, James Zamkutovich. Representing Scott Charles Davis is attorney Mark Bookman. Representing Michael A. Lehman is attorney Lori Yost.
Good afternoon. Appellees were each convicted and sentenced to life imprisonment for murders committed when they were juveniles. Subsequently, appellees were resentenced after mandatory life prison terms for juveniles were declared unconstitutional. As part of the new sentences, the trial courts ordered appellees to pay the costs associated with the resentencing proceedings. The Superior Court vacated the cost portions of the orders, concluding that the trial courts lacked the authority to require the payment of the costs attributable to resentencing when an illegal sentence had been set aside. The Commonwealth is challenging that holding. May begin your argument.
May it please the court. Again, my name is James Zamkutovich, representing Commonwealth of Pennsylvania, York County District Attorney's Office. Your Honors, the Commonwealth's argument in this case is pretty clear, where our position is that the Superior Court exceeded the existing case law of Pennsylvania. The Superior Court, in their panel opinions, cited to Commonwealth versus Weaver, a PA Supreme Court case, and Commonwealth versus Garzone. They based their position that imposition of costs in a resentencing is simply unconstitutional. The Commonwealth has reviewed these cases that were cited to by the Superior Court, and that is not what these cases stand for at all. In Garzone, specifically, the Superior Court held that where a trial court makes a factual determination that the Commonwealth has acted in bad faith or engaged in some sort of waste, that it is within the trial court's discretion to not impose costs regarding that waste or malfeasance upon the defendant. To that end, the Commonwealth has no objection to the imposition of Weaver and Garzone. That seems like a completely reasonable position. It's the blanket barring of trial counsel from imposing costs regarding resentencing that the Commonwealth disagrees with. We've searched case law throughout the United States and as well as Pennsylvania. There does not appear to be any case law that at least this office was able to find in support of the position that it's simply unconstitutional. In applying the U.S. Supreme Court case law that exists, the test for them is set forth in Griffin versus Illinois, U.S. Supreme Court 351 U.S. 12, 1956, which said that the test for imposition of costs and fees is a test of rationality, and that the state's need for revenue to offset costs generally satisfies the rationality requirement. We would agree that Garzone and Weaver are a test of rationality. Is it rational to impose a cost where the cost has been caused by Commonwealth malfeasance? No, that is not rational or reasonable. In this case, we have two juvenile lifers who were required to be resentenced. Their sentences were vacated. Therefore, they were existing in a situation where there was no sentence. Therefore, their convictions were not final at the time that we had these sentencing hearings. We did the evaluations, and in these two cases, they were contested hearings. Defense counsel presented their experts, which we cited to in our brief as to what was being requested. Of course, both the defense experts were saying that the juvenile should have less time. The Commonwealth's expert was saying they should have more time. I would note the Commonwealth's expert in one of the co-defendants' cases to Mr. Lehman was agreed to by defense counsel, and we didn't need to have the cost of an expert testify. In light of this, we believe that the imposition of costs by the trial court was not an unconstitutional imposition. Regarding the question that I've seen in some of the amicus briefs, whether or not imposition of costs of resentencing constitutes cost of prosecution, to that, I would say that the Pennsylvania Supreme Court has specifically defined costs of prosecution as including these types of costs. I would refer to a case cited to in my brief, Commonwealth versus Davey.
Well, we'll look at your brief, and we appreciate the opening, but we've asked you to limit that to 3 minutes, which is now over. So we'll ask the justices to pose to you any questions they might have, starting with Justice Doherty.
Good afternoon, counsel. With regard to the specific statute, 1403, it's discretion of the court to determine whether costs should be paid for the district attorney's investigation, apprehension, and prosecution. It does not say sentencing being separate and different from the prosecution where the burden falls on you beyond a reasonable doubt. Why should we put something into a statute that the General Assembly chose not to?
Very good question, Your Honor. And that is specifically why I was referring to Commonwealth versus Davie. In Commonwealth versus Davie, the Pennsylvania Supreme Court in 1974 specifically decided that where the legislature imposed a requirement that, quote, made all persons convicted of a crime liable for the costs of their prosecution, the Pennsylvania Supreme Court held, quote, it is clear the legislature intended to include in the costs for which a convicted person is liable the cost of all proceedings requisite for final disposition of a case.
But I apologize. That was a extradition case, right?
It was actually a parole violation case, Your Honor. It was subsequent to the conviction.
To bring them correct. But the problem was that the defendant contested the jurisdiction and had to be extradited, something that he or she caused upon their own volition, as opposed to a Supreme Court finding of an illegal sentence causing a resentence. So I can easily distinguish Davie. What else do you have?
Your Honor, there's not a whole lot on this topic. The question as to whether, I guess my main question is the argument whether it simply can't be imposed or whether it can be imposed under reasonable circumstances. If we look at Davie, when the legislature writes their laws, the legislature is forced to rely on what exists. Davie is basically what exists, and it specifically says it includes all proceedings requisite for final disposition. Thus, by referring to costs of prosecution, the legislature could reasonably rely that that's what it would continue to be interpreted to be.
But we could also, if we follow your logic, we can interpret Weaver and Garzone as being, since they were caused by the prosecution and the defendant did not have to bear responsibility, this resentencing was caused by the United States Supreme Court, therefore not the responsibility of the defendant. Fair enough or no?
I would disagree with that, Your Honor. In this case, had the situation never have existed, had we had the sentencing scheme that we have now, where a defendant or a juvenile lifer is subject to a mandatory minimum and then a maximum of a mandatory life, even today, if we want to either ask the court for something that's above the mandatory minimum, or we want to pursue the life without parole, which remains an option if we can show incorrigibility, we would have had to impose those costs at the original time. The fact that those costs never existed in the first sentencing does not mean that they should never exist in this case. Had the error, purportedly, arguably it's an error for the original sentencing, these costs were not repeat costs. They were not costs that should have never been imposed. These are costs that if this case were prosecuted today would be required and simply weren't required of the defendant today. So it's not a duplication of costs. It's not a waste. And therefore, we believe it's appropriate for them to be imposed in this case.
Thank you.
Thanks.
Justice Wecht.
Thank you, Chief Justice. Counsel, the statute says that the defendant must pay the costs of prosecution and trial. If prosecution includes everything, including sentencing, what's the purpose of the words "and trial"?
I would say, Your Honor, the costs it would include the costs of prosecution that go beyond trial. Any type of situation where we're doing a pretrial extradition, if we're doing pretrial hearings, if we're in the juvenile court and we are seeking to have someone certified to adult court, those types of costs wouldn't be trial, but they would be costs relating to the prosecution. By stating that costs of prosecution are to be imposed upon an adult or a defendant that's convicted as an adult, we believe it incorporates all of those costs, including probation violations and subsequent issues such as PCRAs.
Let me ask you, you recognize that in the Batts case, we anticipated that experts are going to be needed in most of these cases, these post-Montgomery cases, right?
Yes, Your Honor.
You recognize that. So, as a constitutional matter, how can we judge that these inmates would be on notice that 35 years or whatever on this kind of a sea change in the law is going to occur? How can, putting aside allegations of malfeasance, there's no allegation in this case of Commonwealth malfeasance. How do we put the burden on the inmate at this point when the Supreme Court of the United States has made this sea change in the law?
The argument in that regard is twofold. First would be, if you're looking at from an ex post facto type situation, the argument is that by imposing a lesser type of situation or granting the defendant an ability to pursue a sentence that is lesser than what was imposed, the fact that there is a cost to receive that benefit should not be just a boon granted to the defendant. As I noted previously in my opening statement, there are defendants, specifically York County defendants, among our, I believe we had 12 juvenile lifers. I recall at least 2, one of which was Mr. Lehman's co-defendant, where we stipulated to experts. There was no cost of expert testimony in those cases. We were in agreement.
But we're talking about the cases where there is a cost, and I'm wondering, is this not akin to making a defendant pay for the invocation or availment of a constitutional right?
In regards to making a defendant pay for invocation of constitutional right, the question set forth by the U.S. Supreme Court is whether or not the imposition of a cost imposes a bar, something that would prevent them from exercising their right. In none of these situations were the defendants precluded by some sort of a cost requirement from actually pursuing their appellate proceedings. In all of these cases, the defendants had experts appointed by the court. The Commonwealth had to seek its own experts, basically as responsive experts. Or at least in one case, I believe the Commonwealth was the only party to seek an expert. And I believe that might have been the one where we were in agreement. Generally speaking, Your Honor, I believe I would argue that there's simply no constitutional violation. A person could reasonably expect that as long as they continue to appeal, there may be costs associated with that appeal.
Thank you.
Thank you. Justice Money,
Sure. No questions.
Justice Bear.
When you look at 1403, similar to what Justice Wecht asked you, it talks about where defendant is convicted and sentenced to pay the cost of prosecution and trial. That's the process by which a criminal defendant is found guilty and incarcerated, and presumably pursuant to the sentence. Here, don't we have the opposite? Here we have a process some 30, 40 years later where there is no conviction, there is no trial, and not only, and the sentence is not about putting him into jail, the resentencing about in accord with a federal court order and the U.S. Supreme Court precedent allowing him to get out of jail. So as a matter of statutory interpretation, how does this possibly fit?
Yes, Your Honor. The procedural posture of all of these cases at sentencing is that under PCRA and the federal habeas petitions, the sentences of life without parole were vacated, thus rendering them in the position of their post-trial have been found guilty or entered their guilty plea, but they are pre-sentencing. So at the point where the new sentence was reimposed, these were not final convictions because their sentences had been vacated by the appellate courts.
It's a convenient fiction. I'm not sure it's a reality. Apropos, and I appreciate it's not binding us, but the Superior Court said it would be unconscionable, I think in Weaver, said it would be unconscionable to impose the sentence and impose the cost and punish these people for vindicating their constitutional rights. Incidentally, are they both out of jail? If you know.
I believe I would have to defer to defense counsel on that one. I believe one of them is definitely out of jail. I can't remember if both are.
Well, the point is that they succeeded. If you had prevailed, they'd both be incarcerated for the indefinite future. So I don't know quite how you charge them with these costs. But I guess you've made your argument. Chief, I have nothing else.
Yeah, thank you. Justice Todd.
Thank you, Chief Justice. Counsel, if we were to accept your theory of this case, is there any limiting principle? For example, hypothetically, what if a case went up on appeal 2 or 3 times? Each time the sentence is vacated and it comes back down for a new sentencing hearing, are we going to sanction imposing costs on the defendant each time?
I believe that's where the Garzone type situation comes through. In that case, the Commonwealth engaged in malfeasance basically through waste. A mistrial occurred, and in the set that was caused by the Commonwealth in that case, and an expert had to be recalled for the second trial. The trial court held that because of the error being on the Commonwealth's fault, that the Commonwealth could not then seek costs for the waste of the retrial. I mean, depending on the circumstances, it would have to be an individualized situation. I can imagine situations where it's simply the U.S. Supreme Court slowly knocking things down a peg by peg by peg. Under those circumstances, rational basis would argue probably more towards the defendant's favor. In this particular situation, this is the first imposition of costs that if the defendants had committed this crime today, under the current scheme of sentencing, that they would be imposed these costs for the first time themselves. So we are not engaged in waste or any type of, and the Commonwealth did not engage in malfeasance. Many of these sentences were upheld multiple times by the Pennsylvania Supreme Court and by federal courts on federal habeas. It was only when the U.S. Supreme Court changed basically the position on mandatory juvenile life that it became a question.
So would you conclude then that there's a limit of 1 time to impose the cost at sentencing unless there's Commonwealth malfeasance?
I would argue that it still remains a rational basis test. I can conceive of rational situations where through the defendant's actions, it could be multiple times. If the defendant raises several PCRA petitions through failures of either defense counsel or the defendant's failure to proceed with certain arguments on his first PCRA or second PCRA, where, for instance, a good example I can think of is Commonwealth versus Jacobs. That's a case where half the case was affirmed in 2005. The other half of the case remains pending PCRA. So even though it's been through the entire system once, it was partially vacated due to the fact that it involved multiple murders. It really depends on a fact-by-fact, case-by-case examination.
Thank you, counsel.
Thank you. We'll conclude with questions by Justice Donahue.
Thank you, Chief. I'm glad I got an opportunity to ask the district attorney this question. And I'm trying to determine whether or not there's symmetry between the first sentence of Section 1403 and the second. The first sentence, the General Assembly mandates that the county pay for, among other things, the cost of expenses of the prosecution. Does the county pay for the expenses related to sentencing?
Up front, Your Honor, yes. The county pays for all of the costs related to prosecuting a case up front.
Do they pay for the costs of sentencing?
I mean, to the extent that the Commonwealth, the DA's office incurs costs and has to call experts, yes. That's actually part of our budget. We normally don't.
Is it fair to say, well, and I'm once again, I'm trying to see if there's symmetry between the first sentence and the second sentence. First sentence, the General Assembly says the county shall pay for the costs of prosecution from their general fund. The second sentence says the defendant shall pay the costs of prosecution. So should we view the statute that way, that if the county is required to pay the expenses related to the sentencing, should we then read costs of prosecution in the second sentence to require the defendant to essentially reimburse those costs of sentencing?
Yes, Your Honor. That's what my position is, that the statute reads. We are required to, for instance, when Dr. Rotenberg submits a bill, the Commonwealth, through its funding received from the general fund of the county, pays his bill. And then the costs of the prosecution are submitted to the court as a request for reimbursement. Basically a quasi form of restitution, but it's submitted as a cost of prosecution.
Generally speaking, counsel, are there costs at expenses related to sentencing or resentencing, as the case may be, other than in those circumstances where you need some time of expert testimony?
Very rare. The majority that I've seen have been in restitution cases where we need to bring in an expert for some sort of evaluation of some sort of property that was destroyed. That seems to be the primary expert that we bring in for sentencing purposes. The other experts that we bring in would be in death penalty cases where we are trying to sentence someone and we need to have psychological or forensic experts testify at the sentencing hearing.
And just as a matter of practice, are those expenses in the ordinary course charged as cost of prosecution against the defendant?
Yes, Your Honor.
Okay, thank you.
Thank you. Thank you. We'll hear now from counsel for the appellee, Bookman. We understand that also that counsel for appellee, Ms. Yost, is present on our WebEx, but available to answer any questions the court might have. But Attorney Bookman will argue on behalf of both appellees. Mr. Bookman.
Mr. Chief Justice, may it please the court, I will, based on the Chief Justice's comments in the last case, I will not describe this case as a simple one. However, this case does rest, both cases rest on a single statute, 16 PS 1403, and it's our position that fundamental tenets of statutory construction resolve this case in favor of Mr. Lehman and Mr. Davis. I don't want to repeat what the questions of some of the earlier justices. The first and last question of any statutory analysis is, what did the General Assembly intend? And to ascertain what they intended, we look at the words that are used and the words that are not used. In this case, the words that are used are clear and unambiguous. Costs of prosecution and trial. As Justice Weck pointed out, if the legislature intended prosecution to include sentencing, then the words "and trial" would be surplusage. And we assume that the legislature intends all the words it uses. At the same time, we look at words that are not used. In this case, the word that is not used is sentencing. And this court has never added words to a statute. We believe that this statute is clear and unambiguous. If this court believes that it is ambiguous in any way, Commonwealth versus Garzone, a case this court decided within the last decade, declared a sister statute, 7708, a statute for the first class of counties, to be a penal statute. That would require this court to read the statute narrowly, strictly, and in favor of the defendants, Mr. Lehman and Mr. Davis. Finally, this court has stated that it will not reach constitutional questions unless absolutely necessary. Obviously, we believe that it is not necessary to reach constitutional questions in this case, but if the court decided otherwise, it's our position that punishing two juvenile lifers for exercising the right to a sentence that complies with the Eighth Amendment and impose costs for which they had no notice would violate due process. And with that, I'm happy to answer any questions from the court.
Thank you. Justice Dougherty.
I have no questions for Mr. Bookman. He summed it up as I expected.
Yeah, I agree. Thank you, Justice Wecht.
Thank you, Chief Justice. Mr. Bookman, if the purpose of the statute is to shift the costs of the prosecution to the wrongdoer, then is it not consistent with that interpretation to include sentencing in the costs imposed on the defendant?
Well, Justice Wecht, certainly the language of the statute would say otherwise. It might be consistent and it might not be consistent. The statute specifically, not specifically, omitted the word sentencing. There are policy disagreements in the case law that talk about the moving the costs of prosecution to the wrongdoer. At the same time, it creates a problem with plea negotiations in the sense that defendants can't anticipate what they might reasonably be asked to pay. In fact, Your Honor, in your question about notice to the defendants came close to that issue, although not 35 years later. So policy debates go either way on this, and I think given that reasonable minds can differ about policy considerations, the language of the statute, I think, should control here.
Given that the Commonwealth has clean hands here, that neither you nor the Commonwealth are responsible for this sea change, it's nobody's fault, so to speak. Why would we not then be bound to default to the General Assembly's intent to shift the obligation from the taxpayer to the wrongdoer once there's a conviction?
Well, I certainly would not agree that that's the General Assembly's intent. But leaving that aside, I think the key question, at least in a due process analysis, is not whether the Commonwealth is at fault, but whether Mr. Lehman or Mr. Davis is at fault. Clearly, neither one of them are at fault. So I think it would be a due process violation to impose cost or punishment, really, on these juvenile lifers after decades of incarceration, simply because they were seeking a sentence that is consistent with the Eighth Amendment. So I don't know if I answered your question, Justice West. I hope I did.
Yes, Mr. Bookman. Thank you, sir.
Thank you, Justice Mundy.
No questions.
Thank you, Justice Bear.
Justice Bear, your mute button.
Thank you. You're on permanent guard for me. I think I appreciate it.
My job.
I do. Counsel, Mr. Bookman, I think you may prevail in this case, but I don't think you prevail on the argument you make. Assume for a second that we have you're a defense counsel, but assume for a second you're defending in a first-degree murder case. And of course, we have the guilt phase and we have the penalty phase. And at the penalty phase, the Commonwealth calls an expert on mental health mitigation or the like. The defendant eventually gets a sentence. Are you telling me that it's the law of the Commonwealth, it's a practice of the Commonwealth, that the costs for the Commonwealth's expert under those facts are not assessed against the defendant?
First, Justice Bear, let me just say I will be happy to win under any argument. But leaving that aside, I cannot think of a capital case in which the costs of prosecution were imposed, and this statute does not allow for that. The statute does not allow for costs of sentencing. But having said that, I cannot think of a single capital case. I'm sorry.
My only reason I interrupt is my time is short. But your position assumes that a sentencing is not a part of a trial.
A sentencing is clearly not part of a trial. There's a recent United States Supreme Court case of Betterman versus Montana that discusses the differences between a trial and a sentencing. I'm not saying that it would be unconstitutional for a sentencing, for costs to be associated with a sentencing, possibly. But we don't have a statute that even allows for that. And I am saying that I'm not aware of a single capital case in which the costs of sentencing were imposed on a defendant.
Are you aware, last question, are you aware of capital cases where the cost of prosecution or merits trial, guilt or innocence, have been imposed, but sentencing has not been?
Justice Bear, I'll be honest with you. I'm not aware of it, but I will say that as a matter of practicality, when if a jury reaches a penalty phase, the options are life without parole or death. So the defendant is not going to be in a position to pay significant costs regardless of the outcome.
I agree. It's like restitution. It can be imposed and not collected. But thank you very much. I understand your answer.
Justice Todd.
Thank you, Chief Justice. Along those same lines, counsel, are both of these defendants now out of jail? Can you confirm that?
Yeah, Mr. Davis is not out of jail, as it turns out. He still remains incarcerated. I believe Mr. Lehman is out of prison.
Ms. Yost, is that correct?
That is correct. He is no longer incarcerated.
Thank you, Bill.
Thank you. Justice Donahue?
Yeah, one question. If I understand your argument correctly, you'd be making the same argument if this were an original sentencing, a juvenile now, not in your client's position, in the resentencing. It would be your position that it would be unconstitutional to impose the costs on a newly convicted juvenile who is required to go through a hearing, as we indicated in Bath?
It would be our position, Justice Donahue, that there's no statute that would allow for that. Now, if there was a statute that allowed for it, then I think the constitutional issues apply to the resentencing aspect. Without a statute, there would be constitutional issues because there would be no notice.
Well, why? I don't, honestly, counsel, I don't understand that. Why is it a different posture in this context in resentencing versus original sentencing?
Well, there would be a due process violation because there'd be punishment that would impact them simply because they were seeking a sentence compliant with the Eighth Amendment, and they'd have no notice of the additional costs of punishment. If this case was an initial sentencing and there was a statute that allowed for costs of sentencing, then there might or might not be constitutional implications, but it would be a different argument.
Okay, thank you.
Thank you. Thanks to both counsel. Obviously a very discrete and finite legal issue. So with that, we'll conclude that argument and commence argument in the next case at 1:25.
The next argument is in the matter of SB versus SS, appeal of SS, Richard Ducote and Victoria McIntyre. Representing appellants is Attorney Richard Ducote. Representing appellee is Attorney Elizabeth Pride.
Good afternoon. A family court judge presiding over a child custody case entered a gag order that restricted appellants from, among other things, directing or encouraging third parties to speak publicly or communicate about the custody case. Appellants lodged an appeal contending that the order violated their rights to free speech pursuant to the United States Constitution and the Pennsylvania Constitution. The Superior Court concluded that the gag order was constitutionally permissible, and this court is now reviewing that determination. Mr. Ducote.
Yes, good afternoon, Mr. Chief Justice and Honorable Justices of the Supreme Court. My name is Richard Ducote. I am not only appearing as counsel for SS, a prominent Pittsburgh physician, but I'm also appearing as a pro se appellant and counsel for my associate, Victoria McIntyre. It is because we are the three gagged parties in this proceeding. Neither I, my associate, or my client can, under this gag order, speak about this case publicly, communicate about the case, or encourage other people to talk about this case, or encourage other people to find out the details of this case. Now, notably, Attorney Pride, who represents the father in this case, and her client, and all the other attorneys who represented my client in the trial court, have absolute, total, unbridled freedom to go on Dr. Phil, to hold a press conference, to stand on the corner, to give newspaper interviews, to do anything else. I, my associate, and my client are the only ones who can't speak about the case. Now, I want to first note that the question that the court granted this review on seems to limit the question to whether or not the prohibition against giving information that could tend to identify the child is permissible. I want to first point out that this order is much broader than that. The first sentence of the gag order that Judge Clark issued, admittedly, without any law that she could find to support it, says, "It is hereby ordered that defendant SS, Richard Ducote, Victoria McIntyre, shall not speak publicly or communicate about this case." And this Commonwealth has a history of protecting free speech more stringently than the United States Constitution does. This gag order only limits the information about the child's name to testimony before legislative bodies. When I told Judge Clark that we wanted to use this case to try and get the law changed, and that we intended to testify before legislative committees, she said that was fine, but my client could not use her name. I asked her if she had to wear a bag over her head. She said, no.
Mr. Ducote, if you want to get the law changed, we're going to let the justices ask some questions with Justice Wecht.
Thank you.
Thank you, Chief Justice. Good afternoon, Mr. Ducote.
Good afternoon, Your Honor.
Sir, is it your position that the gag order merely restricts mother from speaking about, mother and counsel, about the case in a manner that would identify the child or allow identification of the child? Or is it your view that the order restricts all of you from speaking about the case at all, subject to a few limited exceptions?
Well, it's very clear from the language of the case in the sentence that I just read, that is the first sentence, in the order says that we cannot speak publicly or communicate about the case. So that's what it says, and we're the only ones. Again, the other side can talk all they want about the case.
And so, from your perspective, from a free speech, from a First Amendment perspective, as well as the Pennsylvania analog, is it your view that the principal constitutional infirmity of the gag order is its overbreadth?
Well, it certainly is overly broad. However, it's content-based, which is presumptively unconstitutional. It's a prior restraint on speech, which is presumptively unconstitutional. And the Superior Court does not engage in any significant analysis of that requirement or that test for strict scrutiny under the Constitution. One of the phrases that's used in the gag order that is clearly overly broad is we can't share information that, quote, tends to identify the child. Now, I don't know what tends to, how broad that can be interpreted, but even my client's face, she might not say her name, but, she certainly has a face and an identity, and this gag order requires her to give that up.
Thank you.
Thank you.
Justice Mundy.
Justice Mundy, mute button is on.
Sorry, I was doing Justice Bear's trick.
You were
And I'm doing my job.
Would you be as opposed to the order on a constitutional basis if it in fact included the father and father's counsel, or would you still be here today challenging the order?
It would still be unconstitutional, but I think the fact that it does not include them points out that this is not about restricting comment about the case. It's about tending to chill criticism of the court's decision. And I think that's especially troublesome, to think that attorneys and litigants under the threat of incarceration are prohibited to discuss in the public forum disagreements that they have with court rulings is very, very worrisome.
Thank you.
Thank you.
Thank you, Justice Bear.
I'm just as a preface, I'm curious. You said all of your clients' prior counsel. How many of them are there?
There were two other counsel.
Two other, and how long has this case been going on?
This case went on for about 3 years before the appeal.
Okay. I don't believe that this is content-based. I think it's content neutral. You can go to the legislature, you can go to the top of the mountain, and you can scream about prejudice against fathers, favoritism for mothers, splitting of siblings, abuse of children, etc. The only thing you can't do is talk about the specific case, and Judge Clark said the reason for that was she was trying to protect the child, which seems to be legitimate. How are your First Amendment rights constrained in any way, given the freedom you have to speak about everything except to do something that implicates this poor child?
Well, we can't talk about the case. That is content. There are 48,000.
It's not content, excuse me. Again, content is substance. What can you not talk, and I don't want to fight with you, what substance in this area can you not talk about because of this constraint?
Well, you can't talk about what the court did in this case. Again, we have 48,000 new custody cases in the Commonwealth every year.
I think you can, sir. You simply can't name this case. You can.
Well,
I'll get about any of these 48,000 cases.
For example, suppose you have a child in high school who's a star quarterback, and suddenly there's a custody change, and because of the custody change, he won't be playing for this team, and the PTA and the sports reporters want to know what happened to this particular child. Under the principle that the Superior Court sanctioned here, that child's mother or father would not be able to talk about what happened and why it happened and where the child is or anything else. Or if you have a promising 8th grade girl who's going to be in the science fair and they're looking forward to her contribution, and suddenly the custody schedule is changed and she can't participate. Nobody can talk about it. In every custody case, the argument can be made without evidence that talking about the case and discussing this particulars somehow affects the child in a negative way. And once we do that, we license tyranny, in my view.
Well, again, and last question, you don't see the distinction between discussing the broad subjects. Frankly, I think it's not a bad idea that the poor quarterback is not under the pressure of the public newspaper because of his parents' problems. But you don't see the distinction between discussing that issue and not personalizing it to the child.
Well, there's no context, to say that there's a problem in our court system, and you're asked the question, well, what's the evidence of that? Well, it's my case, but I can't talk about it or I'll go to jail. I think that's a very serious problem.
I understand your position. Thanks, Chief.
Thank you.
Thank you, Justice Todd.
Thank you, Chief. Counsel, I am concerned by your characterization of President Judge Clark's order. You indicated, and I'm going to give you an opportunity to correct this if I misunderstood you. I thought you indicated that the gist of her order, her motivation in entering this order, was obviously to prevent you, client, and your client's previous counsel from criticizing Judge Clark. I read it completely differently. I read it as an order entered to protect a child and to protect the child's identity, which is a worthy goal that I believe every justice on this court would endorse to some extent. So could you clarify that for me?
Certainly. And I'm not saying it's to deflect or to prevent criticism of the judge herself. She very clearly said in her ruling, I have no problem with people criticizing me. It's criticizing the decision, the analysis, the conclusion, the ruling. And that's what the criticism is. Otherwise, then nobody could talk about the case. If in fact...
From where do you draw that conclusion that the intent of the order is to prevent criticism?
The fact that it just applies to us. We're the only ones who disagree with the decision. And again, let's go back to the issue of the child's name. The Shep decision, which was the only case that the Superior Court decided, and which was decided by this case in 2006, that case did not involve people talking about the case. It involved a parent being able to discuss with his daughter what was and is a crime, that's bigamy for religious purposes. This court, interestingly enough, even though the Superior Court did not, fully discussed and revealed that 13-year-old child's name. And there have been law review articles that have been written about that case that discuss the child's name. The parents were interviewed. Parents discussed the case. It was a big. It had a lot of interest in the media and in the legal community because of the religious significance.
Let's get back to this case, though. Sure. In this case, isn't it possible that Judge Clark's order only applied to you and your client and her other counsel because you were the only ones at risk of mentioning the child's name or revealing her identification?
Well, that's prior restraint, content-based, and unconstitutional. And again, if that were the case, then why doesn't it apply to everybody? If it were in fact, look, I don't want anybody talking about this case. I don't want this child, and the child has a different name than both parents, different last names. So, once you start putting those sorts of restrictions on a parent tending to identify the child, how can my client explain why suddenly this child who was by her side and with her every day and was well known in the community suddenly disappeared from her life?
So it's your position that you and your client should be free to reveal her name, reveal the child's name whenever you'd like, and her identity.
Well, there are two issues here. Whether that's a good thing to do, and that was never done in the publicity that was given this case. The things that Judge Clark ordered us to take down from the internet, to remove from the other online social media sites, the child's name was never revealed. That was never done. So the notion that even though it was never done in the past, it can be done in the future with an additional layer put upon it that we can't even discuss the case, I think is totally unconstitutional. Nobody mentioned the child's name, but the father can. The father's attorney can. The father's attorney and her client can go and mention my client's name. We can't mention the father's name. It just doesn't make constitutional sense. Thank you.
Thank you. We have approximately 5 minutes left, so I would like to divide that time for questions between Justices Donahue and Justice Doherty, starting with Justice Donahue.
Thank you, Chief. Counsel, could Judge Clark have sealed the record in this case?
She could have, and she didn't, which is another point.
I understand that. Yeah. My question to you is, could she have done that?
She could have.
Okay, and if she had done that, would she not have accomplished much of what is at issue in the order that she entered? Well,
I think there's a common misperception about what a sealed record is. A sealed record means that the public can't go to the prothonotari's office and say, I want to see this SS versus the SP versus SS record. And
it also means that you can't go to the prothonotary's website and publish that information on a website.
Well, it doesn't mean that the case can't be discussed. And that's the critical difference.
No, you're not answering my question. To the extent that she could accomplish prohibiting you from replicating information on the website and sharing it with the public, if she could have done that with a sealing order, why can't she do that with this order?
Sure, because if the record is sealed, that doesn't prohibit anybody from simply talking about what happened in the courtroom. It says that the documents perhaps can't be published or copied or replicated or disseminated, but it doesn't mean that people can't talk about what's already occurred. No case.
Can I just quickly, because my time is limited, does Judge Clark have the authority to place limits on you as an attorney involved in pending litigation in her courtroom that are different than any restrictions that she might place on a non-attorney litigant?
Well, there was no litigation pending. This is all after the fact. So
it's an open case, is it not?
Well, nothing to do with the custody. There's nothing pending. And the only time that any court in this country has sanctioned these sort of gag orders is to prevent tainting a jury in the criminal case. No court has ever sanctioned, and there have been court decisions around the country with these sort of gag orders, and they've always been declared unconstitutional. We've cited that in our brief.
Thank you.
Thank you.
Justice Doherty, do you have a question before we
Yes, just a quick question. I'd like to pick up from where you just left off, counsel. This is not a criminal case. This is a custody case in which the standard would be the best interest of the child. The child also has an expectation to the right of his or her privacy, not to have lurid or details of alleged sexual misconduct brought forth in any shape or form. The granted issue before this court is the manner that would identify the child. Share with me where you think your First Amendment right, as well as your partners and your client, supersedes that of a child's privacy in the specific contours of a custody case.
Well, first of all, if this order simply said that in the discussion of this case, the child's name shall not be revealed, then we would have a different case. But that's not what this gag order says. It says defendant SS, Richard Ducote, and Victoria McIntyre shall not speak publicly or communicate about this case. Now, there's nothing clearer than that gag order that says that we cannot talk about this case, and we can't encourage other people to even find out about the case. I mean, that's unconstitutional.
My question is very specific. The issue in a custody case is the best interest of the child and the child's right to privacy. Please share with me what causes your First Amendment right to trump the child's right to privacy in the determination of its best interest.
Okay, so under that hypothetical or that question,
it's not hypothetical, sir. That's the question before this court.
I understand. Okay, so that under that consideration, there could be a gag order from any parent talking about anything to do with their child. You couldn't tell other parents, you couldn't share with other parents that your child has a medical condition because that child has a right to privacy.
Counsel, I apologize. I would be more specific as to say this gag order was related, if I'm not mistaken, to announcements and statements made via public media and on TV stations, something that does not normally occur in some of the 4,000 custody cases that are filed within this Commonwealth, as you indicated.
Well,
so
it's
gag order specific as to your conduct and the conduct of your client. So this is, again, with regard to the case before this court, which is what you, your client, and your associate did publicly in announcing the tortuous facts of this case, which lasted in a 23-day trial. Share with me where that child's right to privacy is superseded by your right to talk about that child's private life.
The Constitution of the Commonwealth and the First Amendment of the United States of America's Constitution.
And the child's constitutional right to privacy, which is of paramount importance, takes a second seat to your right to speak. Is that what you're saying? It's a yes or no answer, counsel.
No, Your Honor, because the child's privacy, the child's name was never disclosed in any of the discussion that resulted in the gag order. It just simply
Thank you, Mr. Ducote.
If you discuss my name and my wife's name, a majority of people would understand who my children are. You would just have to Google that.
Well, if we take this to be as you're concerned, then a gag order will ensue in every child custody case saying no parent can talk at all about their child. You know, so if you have a child who committed suicide.
You may be right.
Thank you, Mr. Ducote.
On public TV. Thank you, Chief.
Yeah, time is up and exceeded. So we're going to hear from Ms. Pride, counsel for the Appellee.
May it please the court, Elizabeth Pride on behalf of SB. Can you all hear me?
Yes.
Yes.
This question arises in the context of an extraordinary case in which one party is litigated excessively in every level of state court in matters and related matters of both custody and child support in both the state and federal courts. Millions have been spent on litigation in this case, and through it all, the appellant herein has declined to take the reasonable steps necessary to resume her relationship with the child, as outlined in the custody order of December 2016, and has voluntarily not seen or spoken to the child since. Rather, she's made a life's work of litigating and misrepresenting the voluminous evidence in this case that amply demonstrates that the abuser in this case is not the child's father, but the appellant, who has demonstrated an utter indifference to her son's well-being in her quest for attention, which has caused the trial court to step in again to protect the child from her. This is a question of whether the trial judge may limit mother's speech that is determined to be harmful and or dangerous to the well-being of a child. In an argument rife with hyperventilation and obfuscation, mother says that the court may not. Mother's argument boils down to 1, the court owes a great deal of deference and protections to the freedom of speech. 2, any speech on a topic is content-based, thus invoking a strict scrutiny standard. 3, the court failed to provide a legal or factual justification for the restraint on speech, and that the order is not narrowly tailored to serve a significant government interest. 4, that the order was vague and overbroad. And 5, that public policy favors reversal. With regard to the first of these, the court owes a great deal of deference and protections to the freedom of speech. While mother spent more pages and citations documenting this in her brief than any other principal, there's certainly no dispute that that's true. Both the trial court and the superior court were explicitly cognizant of this fact. But no right, even a fundamental right, is unconditional. Mother's own brief acknowledges this, even as she tries to conceal it. So the question is, under what conditions may the trial court in this case place restraints on mother's right to speak about it, and do those conditions exist here? Mother does not address that question in her brief or her argument. Instead, she states and restates her conviction that her right to speak cannot be limited at all. A threshold question in this case is what level of scrutiny must be placed on the trial court's order. Mother insists that strict scrutiny applies because the speech is content-based. In getting to this conclusion, mother ignores the United States Supreme Court's definition of that term, and instead reasons that as the order's application depends entirely on the topic of speech, i.e. this custody case, there is no question that it constitutes a content-based restriction on speech. That's in her brief at 14.
Thank you. We had allowed you a brief period for state your case, which you've now done. So if you'll allow us, we'll proceed. Questioning beginning with Justice Weck.
Thank you, Chief Justice. Good afternoon, Ms. Pride. The question seems not to be the trial court's intentions. Those would appear to be unimpeachable or well motivated, so to speak. Nor does the question of import seem to be mother's conduct. Let's stipulate it's been suboptimal, to say the least. The issue, I think, that's important for this court to address, and I'd like you to comment on, is the question of overbreadth. And the reason I'd like you to comment on overbreadthness is that when we decide this case, our decision will have implications statewide for all custody cases and beyond the area of custody, and not just this case where mothers behaved irresponsibly and the trial court is doing a good job. You see what I mean? The question is, if we affirm here, what is to say that it won't be the default mechanism in every acrimonious custody case, which is quite frequent, that the trial court can just enter an order saying mother and her counsel shall not speak publicly or communicate about this case, including but not limited to, et cetera, et cetera. Particularly in a day of social media, shouldn't we be troubled by the First Amendment implications of that?
The question of overbreadth, I think, goes to whether or not the order was narrowly tailored to accomplish an important governmental interest. In this case, the judge could not have been more clear that this was about the child, not about the message. The judge's order was accompanied by 19 factual findings about the potential harm to the child. And the order states that at the conclusion of the order, it states what it was not meant to do. This order does not prohibit any party or counsel from publicly speaking or expressing an opinion about the judge, including disclosing the entry of this order of court, after the information has been removed as set forth above. However, such expression shall not contain the name of the child or other information which would tend to identify the child. So the question of overbreadth, if the question is whether this order precludes too much speech, I think the court made it very clear exactly what it was trying to accomplish. It was trying to accomplish speech that might identify this child, would expose this child to undue ridicule, scorn, and scrutiny. And as the Superior Court said, the question of whether an order is overbroad is whether or not a person of ordinary intelligence can understand what they're not supposed to be doing.
Well, one of those things, if I may just briefly, because my time is short, ordering a parent, in this case mother, not to publicly state her name. That's quite a stark First Amendment issue, isn't it?
The reason that mother was asked...
I'm not questioning the reasons. I don't have any reason to question the judge's reasons. Her reasons are not it's not like she's an evil genius trying to stamp out free speech in this country. The issue is what was done, not the intention behind it. And how is it that saying a person can't publicly state their name is not overbroad for First Amendment purposes?
Because the question relates to whether the judge's order was narrowly tailored to accomplish what she set out to accomplish, assuming that that was a permissible thing for her to be trying to do. In this case, given the nature of the communication, if she identified, and the nature of the facts of the case, her having identified herself tied the child to the information, to this salacious and disturbing information that mother was disseminating. So it's not a question, nobody is saying mom can't go say her name is, use her name in saying that she is part of a custody case, but she can't go out there and say, this is my name, and these are the things that my son said, and this is his forensic evaluation, and have all that stuff posted online. This was a breathtaking invasion of this child's privacy. And the thing that makes it an invasion of this child's privacy is the identification of this child. And mother's identification of herself, given that she has only one child, given the fact that she was instrumental in getting this child into his small private school where everyone knows who she is and who he is, her using her own name in connecting to this specific information that invades the child's privacy is necessary as a part of the narrowly tailored resolution to the issue that the court was trying to address.
Justice Mundy.
No questions.
Thank you, Justice Bear.
Premised upon your description in response to Justice Weck, is this case sui juris in terms of the actions taken by mother and her counsel, which required the court to provide response, or is it, or as Justice Weck suggested, is this in danger of being replicated in every custody case?
This is an extraordinary case. This case, one of the things that Father suggested here was that this court's order chills other from similar conduct. And I think that question also relates to whether this is something that courts may take as an opportunity to impose similar kinds of restraints on speech in other cases. But let's review what happened in this case. After a 23-day trial in which testified 3 psychological experts and a guardian ad litem, the results of 2 forensic evaluations were submitted. Mother continually raised escalating and fortuitously timed claims that the child had been sexually abused, and the court found that there had been no abuse by the father, but that the child's best interest would be served by being in place in father's sole legal and physical custody. And from that 23 days of trial, mother selected a short excerpt of the child's testimony and the child's second forensic interview in which he had described what he said was abuse by father.
I think I understand that because, again, our time is short here. The draft card case in the U.S. Supreme Court, I think it was O'Brien, U.S. versus O'Brien, it set forth a 4-part test if indeed the content, the speech is content neutral. Is that applicable to this case?
I think it is. The Superior Court, I believe, concluded that the higher strict standard was met by this case, but at the same time didn't reach the O'Brien factors because the higher standard of strict scrutiny had already been met. However, if you look at the standards of strict scrutiny, it's a lower standard. I do believe that it applies in this case because this is content neutral speech. This isn't about whether or not mother agrees with whether or not the court or the government agrees with what mother is saying. This is about protecting the interests of this child.
And Chief, my last question. If we find that this is content neutral, does it then follow that it's not strict scrutiny?
If we find that this is content neutral, yes, I agree that we find that it's not strict scrutiny.
Right.
I think in this case, it meets the strict scrutiny standard, but the court should impose a lower standard for a case like this.
Thank you.
Thank you, Justice Todd.
No questions, Chief.
Thank you, Justice Donahue.
No questions, Chief. Thank you.
Thank you, Justice Doherty, and we'll conclude.
No questions, Chief. Thank you.
Okay, thank you, Ms. Pride. Do you have a word or two you'd like? Although, please believe me, we understand and apprehend your argument.
I'm tempted to say more, Your Honor, but I think I will rest on my laurels.
Thank you. Thanks to.
We got it.
Thanks. We'll resume argument in the final case for the day at 2:10.
Thank you.
Thank you.
The next argument is in re the estate of William K. McAleer. Representing appellant is Stephen J. Del Sol. Representing appellee is Arnold Kaplan.
Good afternoon. Appellant is the trustee of a revocable living trust created to benefit him and appellees. Appellees challenged certain aspects of the administration of the trust, prompting the appellant to retain the services of 2 law firms. In response to subsequent discovery requests related to the payments to those 2 firms, appellant provided significantly redacted copies of the attorney invoices. The trial court directed appellant to forward unredacted invoices. An appellant appealed, claiming attorney-client, and work product privileges. The Superior Court quashed the appeal, concluding that appellant did not offer factual support for his claims. Appellant is challenging those determinations. Mr. Del Sol.
Thank you, Chief Justice Saylor. May it please the court, Stephen Del Sol for appellant William McAleer. I'm mindful of the time constraints given the method of argument, so I just only want to give a very brief general overview of some of the significant background that I think helps put in context the importance of protecting the attorney-client privilege and attorney work product in circumstances involving trustees. Since the death of William McAleer Sr., the creator of the trust for the benefit of his son and 2 stepsons, there has been significant litigation from the Appellee's beneficiaries against the trustee, William McAleer. Those were not just challenges to the ordinary administration or maybe an issue that we'll get into. The line between what is ordinary administration and what is adversarial is not always an easy one to define. After the first partial accounting, the appellees filed objections and cited 21 claims of error. After some contentious litigation, they withdrew, or the Common Pleas Court dismissed every single one of those with prejudice. The trustee was also forced to retain counsel to obtain some lockboxes that the appellees had inappropriately taken that contained estate property. And then finally, with respect to the second and final accounting, the appellees have filed 10 claims of error, one of which is the charge that there were excessive attorney's fees incurred in relation to the adversarial proceedings that were the result of the appellee's own conduct. As you indicated, Mr. Chief Justice, the trustee produced the attorney's invoices. I don't necessarily agree with the characterization that they were completely redacted. Those appear in the reproduced record on pages 200 to 207, and consistent with the legal framework surrounding the production of attorney-client and attorney work product information. The invoices contain the identity of the timekeepers, the amount of time that was incurred, and some descriptions of the services. However, there were certain descriptions that would include that would reveal attorney work product and attorney-client communications that were redacted.
Thank you, Mr. Del Sol. And I believe I said, and maybe incorrectly, significantly. I didn't say completely redacted, and you may differ with that characterization of significantly. But in any event, we'll ask the justices, beginning with Justice Mundy, if they have any questions.
Good afternoon. I do have a question. I'm wondering why this scenario with this relationship of a trustee and beneficiaries in a trust is different than a situation where you would have defense counsel representing 2 defendants when, in fact, there arises a scenario where the defendants have an issue between them that would require you to get separate counsel. Why isn't that the simple solution here? That you would just get separate counsel for the trust and separate counsel for the beneficiaries, or am I missing the picture?
No, I mean, I think that's a fair point, Justice Mundy. I think part of the confusion from the Common Pleas Court, I think in this case, was not recognizing that under the law, the attorney does not represent the estate, and the attorney does not represent the beneficiaries. In a trust situation, the attorney represents the trustee. And so, trustees are called upon to address numerous issues related to the trust, many of which require them to seek legal counsel. And that's a relationship between the trustee and counsel. And the trustee, in order to have confidence that they can seek appropriate counsel and that there's not going to be a potential disclosure of the information that they requested and the information they received, has to feel confident that the traditional rules of attorney-client communication and attorney-work product apply.
Thank you.
Thank you, Justice Bear.
Mr. Dessel, this seems to me to be a tricky case. On one hand, I think this court, certainly I personally, have always protected attorney-client privilege zealously. On the other hand, how does the other side prove its case that trust corpus has been wasted through the payment of fees or however, without being able to get to that information? Do you follow what I'm asking?
I think I do, Justice Bear. And what they required in this case, they raised an objection stating that they thought there were excessive attorney's fees.
Right.
Invoices were produced, and the law in this case, and I think from your court, Levy versus the Senate of PA, talks about attorney-client communications and attorney work products, specifically in the context of billing records. And what the court said is that billing records contain both non-privileged and privileged information. So to answer your question, billing records would have to be produced and were. And that the non-privileged portions of those records could be produced, such as...
And it's your view that if those were produced, that it would give opposing side, the non-trustee beneficiaries, adequate information to be able to prosecute their case?
Yes, it should. And it's just like any other litigation in which billing records are produced if there's a fee application. If there is a claim that maybe there was an over-redaction, courts deal with that all the time.
Of course, here, and I'm sorry to interrupt you, but my time is short. Here, the trial court declined a request for in-camera review.
That's correct.
Do we have to remand this and have the trial court take a look at all of this?
Well, if there is a suggestion that certain redactions were over-redacted, yes, then I think that has to be a review. But within the traditional framework of the attorney-client privilege and attorney-work product.
Fair enough. So we decide that attorney-client is applicable in your estimation, and then a trial court decides whether whatever you have in your records is covered or not covered.
That's correct.
Okay, I got it. Thank you.
Thank you, Justice Todd.
I have no questions, Chief.
Thank you. Justice Donahue.
A point of clarification. What is it you're asking us to do? As I understand it, you do not want us to adopt a fiduciary exception to the attorney-client privilege, but oftentimes in your brief, you'll say, don't adopt the exception, particularly in a case like this with contentious litigation. So which is it? You don't want us to adopt it at all, or you don't want us to adopt it particularly in a case like this?
That's a fair point, and maybe the language of the brief was imprecise, but our position is that, again, the counsel to a trustee represents the trustee, and trustees have to be able to feel confident that they can consult counsel on a variety of complex legal issues relating to trust, whether it's treating different beneficiaries that have different rights differently.
Yeah, I get that, counsel, but what is it you want us to do? Do you want us to say there is no exception, otherwise referred to as the fiduciary exception under Pennsylvania's attorney-client privilege, or do you want us to qualify it?
No, I don't think there should be any fiduciary exception. The attorney-client communication is codified by statute. There's no exception. Similarly, attorney work product is in Rule 4003.3. There is no exception. And the problem, I think, with creating some sort of exception upon this whether it's administrative or adversarial fault line, is that line is frequently blurry. And it's somewhat subjective and difficult to know what is administrative and what is adversarial. And what might be adversarial to one beneficiary, or in the view of one beneficiary, might be just administrative to them, might be deemed adversarial to others. And that creates uncertainty. And as this court has noted, an uncertain privilege is little better than no privilege. And that uncertainty, I think, is going to have a chilling effect on the trustee's willingness and ability to go seek legal counsel. So to answer your question directly, is I don't think there should be any distinction or exception to the or fiduciary exception to the attorney work product or attorney-client communication. It's easiest to see, though, I think, when there is a clear adversarial relationship, as there was in this case. But I don't think that that's a distinction that really should make a difference.
Thank you.
Thank you. Justice Doherty.
My question falls right in line with Justice Donahue. So what is it what is the relief that you request? That it go to the trial court for determination whether the documents fall within an attorney-client privilege?
Well, yes, the trial court just ruled that trial court didn't do any independent examination.
Well, that's what I'm asking you. Are you asking, I apologize, sir. Are you asking us to remand so that they can? Like, what is it? What remedy do you seek? I'm confused as to your remedy.
Sure. Well, we're asking that there be no fiduciary exception adopted. So in this particular case, it should go back to the trial court. If the beneficiaries, the appellees, think that something was over-designated, then yes, the trial court would have to then do an evaluation of those particular entries.
That's what I thought. Thank you.
Thank you, Justice Wecht.
Thank you, Chief Justice. Good afternoon, Mr. Del Sol. In this case, you have an acrimonious situation, litigation between co-beneficiaries. It's not just between beneficiaries and their trustee. Trustee is a co-beneficiary, correct?
That's correct.
And the funds for not one but two law firms, K&L Gates and another firm, were paid out of the trust corpus, not by the trustee, right?
That's correct.
Okay, so you don't want, in that scenario, the beneficiaries who are claiming, without judging the merits, they're claiming or maintaining there's looting or waste or whatever that they want to get at by their co-beneficiary, who happens also to be the trustee, and the corpus to which they're entitled to share is used to pay, but you don't think they should be allowed to look at those bills. Explain that to me.
Yeah, I think they should be allowed to look at the non-privileged portions of those bills.
But they blacked out almost everything.
Well, like I said, if there is a claim that there was an over-redaction, then yes, the trial court does have the ability to say, I've done an in-camera review, and portions that were designated as privileged, I don't believe they are. But that doesn't create a wholesale fiduciary exclusion to attorney work product and attorney-client communication. That doesn't exist.
Wasn't that battle, sorry to interrupt, but again, time is short. Wasn't that battle lost in the orphans court when trustees counsel merely interposed some generalized privilege objection without any particularization?
Well, that's a separate issue. I don't think the battle was lost because the court never engaged the battle and never did the review. But yes, I understand what you're saying. The Common Pleas Court said that the privilege was not preserved. I think that the privilege clearly was preserved in response to the request. The invoices were provided in redacted form consistent with Levy versus the Senate of Pennsylvania. In response to the motion to compel, counsel for the appellant, the trustee, specifically raised both the attorney work product and attorney-client communication and said they are not waiving that.
Last question, and then I'll let other justices ask. I'm sorry, go ahead, sir.
I just want to finish that one point. And she did offer to have an in-camera review. And I think then by saying, given all that it was still waived, it was putting counsel in almost an impossible situation that to do more, she would have had to disclose the privileged information to prove it was privileged. Because there's only so much that you can say or do when invoking the privilege. And I think she did all that.
All right, last question. Isn't it because of acrimonious intra-family trust disputes, just like this one, that the restatement second and third, and Judge Weddick's decision in the other case, all talk about the trustee hiring his or her own counsel? In other words, once this dispute cropped up with their stepbrothers or step-siblings or whatever, why didn't your client light bulb go on and say, oh, we have a dispute about this trust corpus. Rather than grabbing that trust corpus to pay for my attorney, I'm going to pay for the attorney to protect myself against my co-beneficiaries. Why didn't the restatement and the Weddick decision give your client a clear guidance? You know what? I'm on the hook here. I need my own lawyer, rather than using their money to pay for the lawyer against their interest.
Right. Well, the restatement of trust specifically addresses the payment of attorney's fees out of the corpus of the trust. And because it is so important for trustees to have access to counsel and to make sure that they are making appropriate decisions in meeting their obligations as trustees, that the law of trust is that can be paid out of the corpus of the trust. With the Follansbee case, Judge Weddick's case, Follansbee versus Gerlach, it's a 2002 case. What Follansbee held is that the general obligation of a trustee to provide information to the beneficiaries under the restatement section 82, a section that was never adopted in the Commonwealth of Pennsylvania, that just states that the beneficiaries have a reasonable basis to inspect trust documents, records, and property holdings. Now, he made a leap from there to state that includes attorney-client communications, but that is nowhere within the restatement. That's not in Restatement 72 or in the new Restatement section of Trust 173. And in fact, in the newer section, they declined to interpose a fiduciary exception. So Judge Weddick in Follansbee looked at that restatement section that's not the law in Pennsylvania, and he read into it language that respectfully doesn't exist. And he also looked at this court's decision in Ray Rosenblum estate from 1974. And again, that opinion only states that a trustee has a responsibility to provide certain documents of the trust to the beneficiaries so that they understand what their interest is. There is nothing in attorney-client privilege was not even an issue in Rosenblum, and so it's never been addressed. But what's interesting about Follansbee is that even Judge Weddick acknowledges that the relationship is, and this gets to your question, the relationship with counsel is a relationship between trustee and counsel. The counsel represents the trustee, not the beneficiaries or the estate. Even acknowledges that in Follansbee and states that to the extent that the interests are divergent between the beneficiaries and the trustee, that clearly all that would be privilege.
Thank you.
Thank you. You've ably responded to arguments of the justices, Mr. Del Sol. If you had a sentence or two by way of summary, we'll then turn to the appellee.
Yes, thank you, Mr. Chief Justice. Again, we would urge this court to think about this case, and I know we're thinking about the small, narrow confines of this particular case, but the broader ramifications of all the complex issues that trustees face, tax issues, real estate issues, and various things. They must be able to freely consult and obtain legal advice. And if there is a concern about whether that advice will be protected, it will have a chilling effect, which will ultimately impact their ability to perform their obligations. And I think ultimately end up in harm to the trustee, or I'm sorry, harm to the beneficiaries.
Thank you. Mr. Kaplan.
Thank you. May it please the court, my name is Arnold Kaplan. I represent Michael Lang and Stephen Lang, beneficiaries of the trust of their late stepfather, William McAleer. Initially, we submit that the appeal should be quashed because it does not meet the three-pronged standard for review of an interlocutory order pursuant to either the Rules of Appellate Procedure or the Revision Systems versus National Real Estate case. The issue of excessiveness of attorney fees is not a collateral issue. It cannot be separated from the main issue of the case. It is the central and core issue in the case at bar. As stated by both the trial court and the Superior Court, there are no facts of record to support the assertion of privilege. In the Nationwide Mutual versus Fleming case, there's a shifting burden of proof. The appellant needs to first place facts of record by either a pleading, motion for a protective order, but in this situation, the trustee never asserted or placed any facts of the record. Privilege was not properly raised. Your Honors, addressing the merits, in the opinion in the 2002 case, common pleas case of Follinsby versus Gerlach, the Honorable Judge Weddick, he balanced and weighed the interests of the trustee's duties of disclosure under the Uniform Trust Act versus the right of attorney-client privilege. He made reference to Restatement Second of Trusts, and I just want to jump ahead to the Restatement Third of Trusts, which subsequently came out. And it essentially encapsulated the same rationale as Judge Weddick's holding. The critical distinction, and this was mentioned a little bit earlier by Mr. Del Sol, it's hard to define what is an adversarial proceeding. Well, I submit to you, Judge Weddick's holding, Restatement Second and Restatement Third Trust do go to define and clearly what is an adversarial proceeding. The appellant in this case misses the critical distinction in that an adversarial proceeding is to protect the trustee from removal or discharge. Those are words and language from the restatement. This case was lengthy in litigation, but it was always about administrative decisions and actions by the trustee. It was never about surcharge or dismissal. Now, since there are no facts of record asserted by the trustee regarding privilege, it's unclear why two experienced law firms representing the trustee would place privileged information in billing statements involved in a trust. Trustee has a duty of disclosure. Why do it? The answer, it's to shield the bills from the view of the beneficiaries and from the court. In a prior order in this case, our trial judge entered an order reducing an award to the trustee for attorney fees by 80% due to excessiveness of those attorney fees. We submit that because of this earlier order reducing fees, the trustees' attorneys, they learned a lesson. They knew better. They knew better.
Mr. Kaplan, as you know, when we sent you the protocol, we allowed 3 minutes for an opening statement, and you've exceeded that. So we're going to conclude that part and move to the question, starting with Justice Mundy.
I have no questions. Thank you.
Thank you. Justice Bear.
I can't hear you, Your Honor.
Can you hear me now?
Yes, sir. Yes, Your Honor.
Giving up on my notes. Same question that I asked Mr. Del Sol. Can you prove, nobody can discover attorney-client privilege from the opposing side in any lawsuit. In this case, can you prove that the corpus of the trust has been wasted by, which is your theory, by other means than discovering this information?
No, I need this information. I need complete, full, unredacted billing statements. In this case, the payments that were made to the to trustees' counsel out of the corpus of the trust, and which are ultimately being paid by the beneficiaries, it amounts to a pretty staggering amount. In fact, I will tell you that Judge Durkin entered an order precluding any further payment of fees without an additional order of court. And then upon trustees' request for further fees, she said, I need first to see the totality of these bills. So no, we need those bills unredacted.
All right, thank you. Thank you, Chief.
Thank you, Justice Todd.
I have no questions. Thank you.
Thank you, Justice Donahue.
No questions.
Thank you, Justice Dougherty.
No questions.
Thank you, Justice Weck.
Thank you, Chief Justice. Good afternoon, Mr. Kaplan. Did the trial judge, did the orphans court judge so error in this case by declining to conduct an in-camera review? Did that failure to conduct an in-camera review shift the burden back to your clients?
No, Your Honor. There's no error whatsoever. The reason is twofold. First, there are no facts, place of record for use of the privilege and why privileged information was even placed in billing statements. So there's no error. And the second reason is that the beneficiaries who are paying for the bills will need complete and unredacted billing statements to address the central issue of the case, which is excessive fees.
Last question, Mr. Kaplan. Would you agree that a way out of this thicket is for a trustee to hire personal counsel when a dispute arises with co-beneficiaries?
Yes, Your Honor. That was addressed by Judge Weddick in the Follansbee versus Gerlach case. It's also addressed in the restatement second and third of trust. I would submit that the fiduciary exception, as the essence of which was opined by Judge Weddick, says that if the trustee retains separate counsel paid for out of the trustee's own funds and for the protection as against surcharge and or dismissal or removal, that would not be disclosable. That would not be discoverable.
Just very briefly, sir. I'm sorry. Just very briefly. In this particular case, were the two law firms brought on as a result of the dispute with the co-beneficiaries, or were they pre-existing standing trust counsel?
The claim by the trustee is that counsel were brought on because of disputes over administration of the trust. I can't speak for the trustee and as to how or why that occurred. And again, that's why we don't have those facts of record. As there's nothing that's been asserted as to the need for the attorneys and the use of that privileged information or inserting it into bills.
Thank you.
Thank you. Thank you both. Mr. Captain, before we conclude, do you have a word or two of summary?
I do. I know I was given 2 minutes. So again, regarding the merits, in 2019, January of 2019, this court, the court's decision in Pittsburgh History and Landmarks Foundation versus Ziegler, there's a telling footnote, which is a perfect preface for this case. While the Ziegler case did not have facts to support a holding on the issue of a fiduciary exception, specific reference was made to the 2002 Follansbee versus Gerlach case authored by Judge Weddick. Today, this court has an opportunity to resolve an important and as I understand, a recurring issue in trust law and to establish law for the Commonwealth. There should be, for this court, a huge public policy concern for fairness and protection of beneficiaries. There should be a great concern with continuing the business practice as is requested by in the amicus brief by the Pennsylvania bankers. They want to continue business as usual. They don't want necessarily to disclose, full disclose, and be accountable for all of their doings. And so there should be a great concern that unscrupulous attorneys or unscrupulous trustees could pack a billing statement with this privileged information and therefore try to avoid disclosability. This court has an opportunity to adopt what I submit as a logical and common sense rationale of Judge Weddick in the Folensby case. It's a rationale encapsulated and supported by restatement second and third of trust, and we ask that this court confirm a fiduciary exception for trust as the law of Pennsylvania. Thank you.
Thank you, Mr. Kaplan. Thanks, Mr. Del Sol. Thanks to all present. And with that, we'll adjourn court.
Court is adjourned.
Thank you.